This is the Definitely Uncertain podcast, brought to you by Goldrock Capital. Each week, we look at how high net worth families can improve their lives, decisions, and investments in a deeply uncertain world. We always aim to provide practical information, even if we can't offer specific investment advice. Welcome to the Definitely Uncertain podcast. My name is Darren Rockman, and I'm a partner at Goldrock Capital, the 20-year-old multifamily office servicing high net worth families around the world. And with me is my colleague, Mireet Wolf, who is General Counsel at Goldrock Capital. Good morning, Mireet.
Hi, good morning, Darren.
Great to have you back on the show. Thank you very, very much. We are both recording from our homes, mine in Modi'in, Mireet's in Ra'anana, as the country here is once again in lockdown, and we're all sort of having to stay home and away from the office. But we shall soldier on in this uncertain world. So, Mireet, what we wanted to talk about today was wills, which is obviously an issue for most people, and particularly for high net worth families. So let's start with a very simple question. Should I have a will?
So the answer is basically anyone who has any sort of assets and has minor children should have a will, which basically takes care of most of the population. People think that it's only for very wealthy people. Obviously, wealthier people might have more complicated wills, but unless you're a young 22-year-old, living in a rental apartment with $10 in his bank account, it's very important to have a will, both for your assets and your minor children, should you have them. Yes.
I barely remember being a young 20-year-old with $10 in my bank account, but yeah, it was all the time.
That's probably a good thing. Probably a good thing.
Okay,
yes.
So really anybody. Now, what happens if somebody were to not have a will and then died?
So if someone doesn't have a will, it's called intestacy. And basically every country will have the rules of where assets go when someone dies. And of course, they'll also decide about any minor children and who should take the children. But that's not a case anyone should be in or wants to be in. And you'll be surprised at how many people, very famous people, haven't had wills. Bob Marley and Jimi Hendrix died without wills, and it was years and years of in-family fighting. So dying without a will, in a best-case scenario, results in delay. In the worst-case scenario, it can lead to a lot of strife and a lot of fighting, and it may end up that the assets and the children don't end up where you want them to be. So I advise everyone to have a will and to do it correctly.
Well, it sounds a great and terrible irony that the chilled out Bob Marley had people fighting over his estate. But it does happen.
I just actually read that he thought he was never going to die. So, which I want to add, since we're on the topic, that people tend to avoid doing wills for two reasons. One is a fear of their own mortality, fear of dealing with death. And I try to tell people, it's like any other document. Do it, put it aside, and forget about it, and don't even think about it. And then I think people avoid it because there are sometimes complicated decisions to make. And whether that's, again, guardianship for children, whether that's assets and where they're going. And so human nature is to avoid the situation, which is not ever going to be ideal.
Just touch on guardianship for children for a minute, because that's one of the more sensitive issues, particularly for younger families.
Yes. So it's probably clearly more important than where your assets go, because you want to pick people that will raise your children in the value system that you would have wanted to raise your own children. But you also have to think about practicality. So, for example, very often people want to pick parents, and we'll tell them, well, just think about it. Your parents are in their 60s or 70s. If, God forbid, this situation happens, are they really in a position to run after a 5-year-old or a 10-year-old? I had someone who said to me that he lived in America and he picked his sister to be a guardian. She lived in Israel because he said, I always wanted to live in Israel, and this way my children will move to Israel even if I don't. That was very warming. But on the other hand, I thought about these poor children who have lost their parents, now being shipped 6,000 miles across the ocean, and a new language, a new culture, a new country. Is that really the best choice? So it has to be made very carefully. And of course, you should tell the people who you pick as guardians. You don't have to, But first of all, they can refuse if they don't want to serve in that role. And also, you don't want to surprise anyone with that sort of appointment. You want to make sure that they're comfortable and on board with it.
Right. Well, great. Well, one of the great advantages of wills is that it's always the last will which applies, which gives people flexibility and the ability to redo their wills from time to time. How often should somebody review and revise their will?
So I use the 5-year rule of thumb. That's not etched in stone anywhere, which is every 5 years, you should take a look at your will. You've changed, you're 5 years older, your children are 5 years older, your assets may have grown. You're out of that rent stabilized apartment in New York City and actually may own a property now. So it's always a good idea every 5 years to take a look at your will. The second point when you should be looking at wills is what I call life changes. Births, divorces, marriages, deaths, anything that happens in your family, in your world that would require you to change a will. And this is really important. For example, if you're getting divorced, if you haven't finalized the divorce and your will still leaves it to your spouse, you could be in a lot of, your money may end up with someone who's not actually yet your former spouse. So you want to be really assured that among many other things in life changes, you go and you have a lawyer look at the will. And of course, if there's changes in the law, this is specifically important in countries that have estate and inheritance tax systems. For example, in the United States in 2016, there was a major change to the estate tax regime. And that's also a good idea at those times to have someone look at your wills to see if they're still tax efficient and doing what they should.
Okay, so we touched a moment ago on guardianship as one of the issues you need to think about when drafting a will. What are some of the other issues that often come up?
So there's a lot of decisions to be made, not just who you're leaving your assets to, but how you're leaving them to them and at what ages. So for example, with children, an 18-year-old can get your entire estate, but you may not want an 18-year-old to get your estate. So it's very important to think about what they're getting, what ages they're going to get it, how they're going to get it. If you want to leave money to charity, that's also something. Do I want to leave money to charity? How much do I want to leave? To what charities? All sorts of questions like that. Of course, I mentioned before, any tax, any countries that have tax, you're going to want to put in your will anything that can minimize any tax liability to the estate. These are, I see these very simply, but they're not simple decisions. And I also caution my clients because there's a tendency to try to rule from the grave and try to control. And you cannot control everything. You just can't. You cannot anticipate every situation. Years ago, I heard about a client that went to her lawyer and said she didn't like her daughter-in-law. So she didn't want to leave money to her son. But she agreed. She said, put it in the will that when he's 60, he gets the money. So the lawyer said to her, why at 60? What if he's still married to this daughter-in-law? And the client said, if he's still married to that good for nothing, give him the money. So again, at some point, you have to trust that you've raised your children properly or that the beneficiaries are going to do with the money what you had hoped they would do. Again, in extenuating circumstances that you may want to tie money up for a very, very long time, but you have to balance your wishes with what they do with the money versus believing in people and also, giving up control, which, by the way, is why a lot of famous people very rich and powerful people don't do wills, because it's the sense of having to give up control and give up.
And of course, when you create your will, very often you can do things in multiple stages, so or different scenarios. So if a spouse is still alive, more assets or all the assets can go to them, and if they're not alive, you're then able to direct it in another direction.
Correct, and it's important to bring up one other issue that is very common, obviously, in today's times, which is blended families and second marriages. A lot of people think, and this is very important when you do a will, that you do not leave anything unsaid, meaning a lot of people believe that their beneficiaries will fulfill their wishes without being told what to do. So, for example, if you have a second spouse and you have children from the first marriage, you are going to want to take care of everybody in the will. Do not rely on your current spouse to take care of the children from the first marriage. And it's interesting because during Zoom, I read a novel by Anne Patchett called The Dutch House, which is an extreme situation where the second spouse not only didn't take care of the minor children from the first marriage, but threw them out of the house. It was a great novel. It was a great read. But the point was that this happens more often than you would think. So put in writing what you want to happen and put in writing who you want to take care of.
Right.
And that writing, by the way, can be in a letter of wishes. So, for example,
what is a letter of wishes?
A letter of wishes is not a binding document, meaning it's not a will. So a court doesn't have to enforce it, but it is often done, and we've had our clients work with their lawyers to do this, where along with the will, it will say, dear, to the beneficiaries, I'm leaving you, for example, I'm leaving you all this money. I've put no restrictions on the money, but I would, for example, like you to use it for higher education or to buy a house or to open a business that you never had a chance to open. It's not binding, but it does help direct and express what your wishes are. So again, things that you may not want to put into a will because you don't want to tie people's hands. So for example, a child may need the money to pay rent and can't go to college. So you don't want him to be in that situation where he can't use the money for what he actually needs. But this way you've expressed to him what you want him to do with it if he can. He or she can.
Right. We've all heard of the famous cases of wills that get contested, and famous families slogging it out in court, one against the other. And I think that anybody that sees articles both is amazed and also scared that such things shouldn't happen to them with the beneficiaries of their wills. What would you say are some of the things that people can do in order to try and minimize the potential for a will to be contested after you die?
Right. It's a great question because it gives me the opportunity to tell another story about a famous woman, Aretha Franklin. Aretha Franklin died, and first they thought she died without a will. It turns out she had handwritten wills under her couch and in a locked cabinet somewhere in her house. And now all the beneficiaries are fighting. And the lesson to be learned there, and advice in response to your question, is first of all, and I know doctors hate the internet for the same reason, you should not be lawyering off the internet. A lot of people, especially people that don't have large estates, think, oh, I can just do it myself. Wills are very formal documents. Even in 2020, there's a lot of bells and whistles that need to be in a will to show that it's done properly. So my first piece of advice to avoid the situation is get a professional to do your will. Don't do it yourself. Don't cut and paste. So that right away will mitigate the chances of a will being challenged. There are times, by the way, that wills have clauses. Many wills have clauses that say that if someone challenges the will, they'll lose any right to a share under the will. So that's another protection that lawyers, depending on what country you are, will add it to protect. And thirdly, what I would tell people to do is if you think there's a chance, if you're doing something out of the ordinary, you may want to discuss it with people, with your children, with your spouse beforehand. So for example, and I'm not recommending leaving more to one child versus another child. That's a very, very dangerous decision to make. It sometimes has to be made, but it has to be done very carefully. But if you're doing something that you see can open the door, then it probably is best while you're alive to sit everyone down, to make it clear that those are your wishes. This is what I'm doing. This is why I'm doing it. Now, the person who gets the lower share may push back on it. He or she may even change your mind, which is fine. I think it's a healthy family discussion to have, but at least it makes expectations very clear. And I think those are the things that can be done. You can't 100%, anyone can go to court. You can't necessarily prevent that. But again, if you do things with a professional, if anything's out of the ordinary, you sort of, manage expectations, you're going to be in a much better place than, others. So that's the steps I would recommend.
And of course, as Aretha would have said, teach your children RESPECT. That also helps. Okay. What about?
And by the way, on that note, Darren, it is astonishing. And when you read the articles about Aretha, she was a very savvy businesswoman, and she was worth quite a large, sum of money. And apparently, she planned her business dealings very carefully. So this was a shock to all that knew her. So
right.
Yes.
Mm-hmm. Okay. Well, let's move now to an issue that often high net worths, certainly in a global world, have, which is assets in more than one country. Many people have funds, real estate, other holdings, holiday homes in different countries. And that obviously is a complication because when you write a will, you write it usually in the country where you are resident.
Right. So we have moved into a new realm of estate planning because people do travel and have assets and move. Certainly, it's not practical to have wills in 20 places, assuming, let's say, you have assets in 20 places, and people don't do that. There's actually two schools of thought. Some professionals believe you just have one will. That will governs your assets all over the world, end of story. There are other professionals that will sometimes, and this also has to be done very carefully with professionals, recommend a second will, very often with personal residences. So for example, there's a lawyer that I work with. She has clients who live in the UK, so have a UK will, but they owned property in Israel, a personal residence. They did not have an Israeli will. The person died in the UK, and now she's dealing with Israeli courts because Israeli wills like to see, the Israeli courts like to see in the wills the property mentioned by name, by block, by lot number, which is clearly not done in the UK. So she said in the end, the property will end up where it should go, but after much time and delay, and she would have told the client during his life, just have a one-page Israeli will, have someone draw it up to deal with the Israeli property. If you're going to do that, again, only with professional advice and make sure that the two wills work hand in hand. That's the biggest danger of having multiple wills, is that one would contradict another. So,
of course, and of course, because the last will is the one that is the one that counts, you
right.
can end up making a real mess of things, and I've actually seen that happen.
That's right. So proceed with caution. Again, if you certainly should be consulting with professionals if you have residences in different countries, and on that level to get the best advice as to what to do.
And obviously, it's vital that the will is kept in a place where your family knows where it is. What other documents should be kept alongside a will? What other documents? People are thinking about this process. It's a difficult process, not something anybody really likes. Every time my wife and I sit down to do this every 5 or 7 years, it's always an emotional moment. Are there other documents you need to be thinking about as well?
So when you're doing your wills, and that's why we call it estate planning, because it's more than just a will. There's lots of documents. First of all, a lot of pension plans, retirement plans, insurance don't work under the will. They have their own beneficiary designation forms. So a lot of assets don't even come under the will. They come under a special form for that asset. So you need to make sure those are filled out. Those are filled out correctly and accurately, and that those work well with your overall estate plan. So for example, if your spouse is going to get all your retirement plan money, you may end up leaving your children more under the will. So it has to be a full picture. And then there are documents that should be done because you will need them during your life. For example, power of attorney. When someone is mentally incapacitated, he or she will need someone to manage his financial affairs and his accounts and checks and all sorts of things like that. Every country has their own specific power of attorney form. Once again, it's a very formal system. You want to do it right with a professional. Medical directives and first of all, you want to appoint someone to make your medical decisions if you can't make them because you're no longer, mentally competent or awake or sound mind. And you also want to direct them in a medical directive what your medical wishes are. Do not resuscitate me. Yes, resuscitate me, feeding tube, those sorts of decisions you should make, and they should be contained in a document. And again, every country has its own system of what these documents should look like. Most of them are actually statutory forms, very specific language. So very important to work with professionals on that. And this can all be done at once so that you make the hard decisions, you deal with it every 5 or 7 years. You put them somewhere safe that's waterproof, fireproof, where your family members know, hopefully not to need them for a very long time.
Okay. Well, that's fantastic. And I think as we've talked about professionals, everybody should take away one lesson, which is you need to do this with professionals. We're not giving legal advice, but Mireet has taught me very well to make sure we tell everybody that this is not legal advice. But these are some really great guidelines for people to be thinking about as they approach the process, and people should not be afraid to approach the process because it really is very, very important. Mireet Wolf, thank you very, very much. That was really terrific. Thanks everybody for tuning in to this episode of Definitely Uncertain. Thanks to our producer, Andrea Herman, and to our editor, Bill Schlesinger. And we look forward to seeing you next time on the podcast. Thanks, everybody.